everybody, welcome to iExamB's Legal Beat. This is Amrita, your law faculty here at iExamB. In this video today, I'm going to discuss with you all the important cases for constitutional law, and this is for CBI APP examination. This exam is going to be conducted soon on 17th of December. So definitely this video can be a very quick revision for all the important cases, though the list will not be exhaustive, but definitely I will try to cover as much as I can in this video. And आपको एक गाइडलाइन भी मिल जाएगा कि आपको केसेस किस तरीके से पढ़ने हैं और आप इस तरीके से इस लाइंस पर अपनी प्रिपरेशन को फेस कर सकते हैं. This video is not only relevant for CBI APP, but it is also relevant for other exams like judiciary and also for practicing advocates, law students, those who need to study the cases for their examination. And practicing advocates indeed have to study cases all the time because you are in the discipline of law. Case laws are a very important area for you for competitive exams and also for law practice and also for your studies. So if you have any queries, you can reach out to us. And इस तरीके के वीडियोस के लिए लीगल बी को सब्सक्राइब करना ना भूलें. You can also write to us an email on hello@iexamb.com if you have any queries. आप 9205524028 पे कॉल करके भी अपने queries resolve कर सकते हैं. And you can visit our website www.iexamb.com and check out all the courses available, and also the demo courses are available. You can check that as well. As I told you, CBI APP एग्जाम के बारे में हम लोग इस वीडियो में डिस्कस करने वाले हैं. We are going to discuss the landmark cases. And why we are discussing the landmark cases? Because in this exam, case laws are asked. Definitely they will try to focus on the areas which are very important and landmark cases. And कुछ areas जैसे कि criminal law, इस पर भी मैंने एक वीडियो बनाया है. अभी आपने अगर चेक नहीं किया है, यू कैन चेक इट आउट इन द प्लेलिस्ट ऑफ लीगल बी. एंड आज के वीडियो में हम लोग कॉन्स्टिट्यूशनल लॉ के केसेस पढ़ने वाले हैं. यू डोंट हैव टू गो इन टू ईच एंड एवरी डिटेलिंग और द फैक्ट्स, बट व्हाट इज द मेन रेशियो लेट डाउन इन दैट केस इज वेरी इंपॉर्टेंट फॉर यू. जस्ट हैव अ ब्रीफ समरी ऑफ इट, दैट मच इज इनफ, but try to cover comprehensively all the important cases. First one is Sajjan Singh versus State of Punjab 1965, which we are going to cover today. In this, the 17th Constitutional Amendment Act 1964 was challenged before the Apex Court on the ground that it has affected the powers that are prescribed under Article 226 of the Constitution of India and has not followed the special procedure as it is laid down under Article 368 of the Constitution of India. So this is what is discussed in this particular case. And the Shankari Prasad case, this case also had come earlier. That question was only raised again in this case, whether the fundamental rights can be amended or not. ये सबसे main question है यहाँ पे. So the Supreme Court held that Article 368 of the Constitution empowers the Parliament to amend any article of the Constitution. So it was said that Article 13 is just limited to ordinary laws and it is not applicable to constitutional amendments. And the scope of Article 368 is limited to constitutional law only. According to the majority decision, it was held that Parliament has the power to amend fundamental rights of the people. So ये काफ़ी जो डाइकोटोमी है fundamental rights और directive principles के बीच में, इससे related काफ़ी सारे cases हैं जो finally settled हुए केशवानंद भारती केस में एंड मिनर्वा मिल्स केस में भी, और बेसिक स्ट्रक्चर डॉक्ट्रिन. तो ये एरिया आपको क्लियर होना चाहिए कि कौन से केस में क्या हुआ था. सज्जन सिंह शंकर प्रसाद क्लियर है. अब आईसी गोलकनाथ के बारे में बात करते हैं. आईसी गोलकनाथ वर्सेस स्टेट ऑफ पंजाब 1967. इन दिस द मेजॉरिटी सेड दैट फंडामेंटल राइट्स आर सेम एज द नेचुरल राइट्स. So these rights are important for growth and development of a human being, and power of Parliament to amend the Constitution. In this case, court held that Article 368 provides procedure for constitutional amendments, and amendment to the Constitution is law as per Article 13 of the Indian Constitution. ये नहीं कह सकते कि Article 13 में constitutional amendment नहीं आता. इस केस में recognize किया गया था. And basically then we come to the Keswanand Bharti case. You can note down the full citation of this case. It is very landmark as it talks about the basic structure. It is one of supremely memorable cases. So this definitely you cannot eliminate. And I would suggest all of you to go through the summary of it. Case तो बहुत बड़ा है, लेकिन आप उसकी summary ज़रूर पढ़ सकते हैं. 13 judge bench was there in this case. and 7:6 ratio judgment was delivered in this case. What was the outcome of this case? It was basic structure doctrine, which is really a very remarkable contribution of judiciary. Supreme Court has held that not even a single part of the constitution, including fundamental rights, was beyond the amending power of the parliament. However, what is important starts here. However, the basic structure of the constitution must not be abrogated even through a constitutional amendment. So it is not that fundamental rights are beyond the domain of amending power of parliament. No, parliament can amend it, but the basic structure should not be touched. Basic structure should not be abrogated. This is what is the thing which is a very balancing and a very balancing judgment and a very nice contribution of judiciary. So in this case, Keshwanand Bharati lost his case partially, but this case has become very landmark in Indian democracy. Judgment has listed some basic structure features of the constitution, which you can see all these are part of basic structure. Principles or features of basic structure: supremacy of constitution, unity and integrity and sovereignty of India, that is also basic structure. Democratic and republican form of government, federal character of the constitution, individual freedom, separation of power, secular character of the constitution. Some more features were added later: rule of law, judicial review, parliamentary system, rule of equality, harmony and balance between the fundamental rights and DPSPs, free and fair elections, limited power of parliament to amend the constitution, power of Supreme Court of India under Article 32, 136, 142 and 147. All of these powers of Supreme Court under these articles are also a part of basic structure of the constitution. Why it is important? To protect judicial review, to protect the powers of Supreme Court, or else there will be transgression of power and there won't be any rule of law, because Supreme Court is the custodian of constitution and will be checking on all these transgression of powers if any take place. So Supreme Court acts as the custodian of constitution. So definitely this is also a basic feature. Power of High Court under 226 and 227 is also covered under this. So writ jurisdiction भी इसमें आ जाता है. In this judgment, Supreme Court also overturned its earlier decision in Ray Birubari case. That is also an important area again. Ray Birubari case है वो भी आप एक बार पढ़ लीजिए. Preamble is considered as a part of the constitution and it can also be amended under Article 368. Full bench majority held that objectives specified in the preamble are also basic structure of the constitution. So preamble को हम constitution का part मानेंगे. And we all know 42nd amendment में preamble amend भी किया गया था and these terms were added: socialist, secular, integrity. ये भी question कई बार पूछा जाता है. It's very very important. ऐसे अगर कुछ important amendments है तो वो भी आपको याद रखने ज़रूरी है, जिसमें जैसे कि 42nd तो बहुत ही ज़्यादा लैंडमार्क अमेंडमेंट है, मिनी कॉन्स्टिट्यूशन ही कहा जाता है उसे. सो ऐसे तो अमेंडमेंट्स आपको याद रखने ही होंगे. इंदिरा नेहरू गांधी वर्सेस राजनारायण केस 1975, ये इलेक्शंस के लिए और डेमोक्रेसी के लिए काफ़ी इंपॉर्टेंट केस है. बेसिक स्ट्रक्चर के हिसाब से इस केस में 39th अमेंडमेंट के बाद जो क्लॉज 4 इंसर्ट किया गया था आर्टिकल 329A का, दैट वाज struck down by Supreme Court on the grounds that it was beyond the Parliament's amending power as it destroyed the Constitution's basic features. So basic structure, basic features को आप अगर abrogate करते हैं, your act will become void and it will become absolutely unconstitutional. 39th Amendment Act was passed by the Parliament during the emergency period. So taking advantage of the emergency period, the Parliament had taken this decision. So this was curtailed down by the Supreme Court. So this is also very important. मिनर्वा मिल्स केस 1980, ये केस अलाइड चलता है केशवनंद भारती के बाद, क्योंकि इस केस में वापस से एक अटेम्प्ट था पार्लियामेंट की तरफ से टू curtail the democracy, we can say, become more powerful. Judgment has struck down those changes also which were made by 42nd Amendment itself. 42nd Amendment में काफ़ी सारे changes हुए, मिनी कॉन्स्टिट्यूशन इसलिए कहा जाता है उसे. सो उसमें 2 changes किए गए. बेसिक स्ट्रक्चर डॉक्ट्रिन अप्लाई करके मिनर्वा मिल्स केस ने उस डॉक्ट्रिन को स्ट्रेंथन कर लिया है एंड दिस मेक्स इट क्लियर दैट कॉन्स्टिट्यूशन इज सुप्रीम एंड नॉट द पार्लियामेंट. Judicial review and balance between fundamental rights and DPSP. These things are very, very important features of basic structure, and judges also ruled that a limited amending power is a basic feature of the constitution. यानी कि अमेंडमेंट करना ये भी एक बेसिक फीचर या बेसिक स्ट्रक्चर का पार्ट है. सो ये केस काफ़ी ज़्यादा स्ट्रेंथन करता है बेसिक स्ट्रक्चर डॉक्ट्रिन को. सो ये सारे केसेस में सजेस्ट करूँगी आप लोग ध्यान से पढ़ें. एंड अगर हम डाइकोटोमी बिटवीन DPSP और फंडामेंटल राइट्स की बात करें सो इस केस में वो भी एस्टैब्लिश हो जाता है दैट both of them will be harmoniously interpreted. Doctrine of harmonious instruction becomes very important over here. Construction. So doctrines also, such kind of important doctrines also you should be studying. Vaman Rao case 1981. In this case, the Supreme Court again reiterated the basic structure doctrine only. It drew a line of demarcation on April 24th, 1973, that is date of Keshwan Bharti judgment, and held that it should not be applied retrospectively to reopen the validity of any amendment to the constitution. यानी कि ये भी काफ़ी important point है जो केशवानंद भारती केस के continuance में ही चल रहा है. दैट अगर केशवानंद भारती केस में कोई जजमेंट दिया है, बेसिक स्ट्रक्चर है, अमेंडमेंट्स को चैलेंज कर रहे हैं तो बेसिक स्ट्रक्चर चेक करना है, बट इट कैन नॉट रीओपन अ प्रीवियस जजमेंट दैट केम बिफोर दिस डेट. इट कैन नॉट अप्लाई रिट्रोस्पेक्टिवली. सो दैट इज समथिंग विच इज़ इम्पॉर्टेंट. इस केस में जैसे ये बात क्लियर कर दी गई थी. केशवानंद भारती केस का एक्चुअल मुद्दा रिलेटिंग टू लैंड रिफॉर्म्स था. सो दैट इज समथिंग विच इज क्लियर टू अस. यू कैन स्टडी द फैक्ट्स ऑल्सो. In Vaman Rao case, Article 13(2) has also been discussed, and it was held that amendments made to 9 schedule until the Keshwanand Bharti judgment are valid, and those passed after that date can be subjected to scrutiny only. So this is also an allied judgment with Keshwanand Bharti case. ADM Jabalpur versus Shivkant Shukla 1975. This is very, very important case during emergency, and this is also known as the habeas corpus case. It is very landmark. एमरजेंसी में बहुत चीज़ों का फ़ायदा उठाया गया था. ऑपोजिशन लीडर्स वर इलीगली डिटेन्ड एट दैट टाइम. दिस इज समथिंग विच इज़ अ वेरी बिग थ्रेट ऑन डेमोक्रेसी ऑल्सो, एंड ऑल्सो ऑन द राइट टू लाइफ ऑफ अ पर्सन. वी हैव रिट jurisdiction, we have habeas corpus. So right to move high courts under Article 226 during emergency was an issue that was addressed in this case. SP Gupta versus President of India case 1981. This is a very big case again, because यहाँ पर those high courts who had issued habeas corpus petitions in the ADM Jabalpur case, these are correlated, इसलिए मैंने एक ही slide पे लिया है. In that case, they were transferred. Why they were transferred? That means the judiciary is not able to work independently. Now, independence of judiciary is a basic structure, basic feature of the constitution. Basic structure में आता है. So if you are transferring the judges for giving a judgment that is very fair, then that is something which has to be challenged again. So this action of the government was challenged in SP Gupta case. So this is also known as the judges transfer case. Major issue in this case was relating to appointment of judges of high courts and supreme courts. ये उनके ट्रांसफ़र क्यों किए गए. यहाँ पे एक और एक केस है एडवोकेट ऑन रिकॉर्ड्स एसोसिएशन, वो भी अभी मुझे याद आ रहा है, वो भी आपको पढ़ना चाहिए. There are many cases. Constitutional law में तो limit ही नहीं है. There are many cases. Still I have tried to cover different areas of cases so that you get an idea. अगर आपको उससे related और cases भी ध्यान में आ जाते हैं, you can read it simultaneously. Indra Savani and others versus Union of India and others. This is also very celebrated judgment. Supreme Court of India upheld the concept of reservations as a means of achieving social justice and uplifting marginalized sections of society in this judgment. ये आर्टिकल 16 कवर करता है. दिस पर्टिकुलर जजमेंट इज इम्पॉर्टेंट फॉर दैट पर्पस एंड इट हैज़ पुट अ सीलिंग लिमिट ऑन रिजर्वेशंस. दिस इज द मोस्ट इम्पॉर्टेंट थिंग. टिल टुडे मेनी पीपल आर ट्राइंग टू challenge reservations in various states. Also you will see that so many objections are being taken that reservations should be increased for this community, that community, it should be more. But then this landmark judgment of Supreme Court is valid till today. It is prevailing, which is saying that judgment has clarified that reservations under Article 16(4) should not surpass the 50% limit. as exceeding it could undermine equality and lead to reverse discrimination against deserving candidates. Too much of positive discrimination can also lead to reverse discrimination. This concept gets clear over here to us. Now, what is this positive discrimination? When you are putting reservations, that is a kind of positive discrimination, and therefore it is not affected by Article 14. It is permissible discrimination that you are doing. But if it is in 50% limit, it is okay. This is a ceiling limit. If it exceeds that, then the people who are actually deserving, against them you are doing a discrimination. That is what is held in this case. This is also very landmark case for us to understand Article 16, equality, and all these principles, reservation, everything will be clear in this case. But ultimately you have to go through the summary of it and have a basic idea. What is the provision of law and what was the ratio that was held in the case is something is enough for you from exam point of view. I am telling right now. Okay. जो जनरल में इस वीडियो को सुन रहे हैं to enhance their knowledge, then definitely you should go in details, you should go through the cases, you should read the judgments. That is something which is really important. Have the habit of reading the judgments. Okay, and don't be lethargic in that. Try to read it. You will have a lot of enhancement in your knowledge, and your basic concepts will be clear. That will automatically happen. So you are having this asset in your hands, utilize it. An exam point of view से आप summaries पढ़ सकते हैं. Later on you can enhance and build your knowledge, no doubt. So all the best for your exam, everybody. Exam is near, but stay cool, stay calm, study hard. You will definitely qualify the examination, and also study smart. Don't forget to do that. Have a good day.